name is Nathan Jones and I'm a Senior Associate in the Litigation and Dispute Resolution team at McCabe Curwood. Today I'm going to be talking briefly about costs orders against non-parties. It is well known that generally the unsuccessful party is ordered to pay the costs of litigation. However, what can be overlooked is the fact that in an appropriate case, the court may make a costs order against a non-party. This was demonstrated in the recent case of In the Matter of Vanguard 2017, a decision of Justice Thorley in the Federal Court delivered in September 2018. After Vanguard served a statutory demand on another company, Modena, it commenced proceedings to have Modena wound up and a liquidator appointed. Modena indicated its intention to oppose the winding up order on the basis that it was, in fact, solvent. Modena served an affidavit prepared by its external accountant, who deposed that Modena is now, and has at all times, been able to pay its debts as and when they fall due. However, the affidavit failed to annex a single financial record which evidenced the company's solvency. The same accountant later swore a second affidavit in which he deposed that he had prepared Modena's current annual financial statements and that these indicate Modena's solvency. This affidavit also did not annex a single financial record, but rather said that such records would be available at hearing if required. At the hearing, Modena did not submit that it was solvent. It neither consented to nor opposed a winding up order, which was granted by the court. Vanguard then sought a costs order be made against the sole director of Modena, a Mr. Carr. The court was very critical of the evidence of Modena's accountant that I just referred to, and was ultimately persuaded to order that Mr. Carr pay Vanguard's costs of the proceedings. The relevant factors included: Mr. Carr, as the sole director of Modena, played an active role in the conduct of the litigation. He procured Modena to conduct its defence of the proceedings in reliance on evidence that he knew was inadequate to prove solvency and/or knew to be misleading. And finally, the conduct of the litigation in this way had the consequence of increasing Vanguard's costs, which would probably be irrecoverable in the winding up. The message from this case is quite clear. Although it is understandable that a defendant may wish to vigorously defend proceedings, particularly a winding up application, there are limits and a line that cannot be crossed. Directors need to be careful to never cause their company to mislead the opposing party and/or the court, or to make groundless contentions, including in affidavits deposed to by other persons. If a director or some other third party crosses this line, then the court may order that the non-party pay the costs of litigation. There is more about this case, if you're interested, on our website.